My name is Mark Bissett. I'm from Clyde & Coates, international law firm with a specialism in aviation. I've done business jet finance for about 25 years, which, if nothing else, shows that it's probably about time to retire and do something else in life. But I think certainly most of the business jets finance work I've done has been for private wealth banks, but I've also acted for owners and operators. So I think I can safely say I can see the financings from all perspectives. That dare one say I do have a bit of a bias, which will probably come out towards the financiers. And as I think you'll see as we come on to, there's often a tension in business jet financing between the financiers and the operators, in particular in some of the demands that the financiers make on the operators, as we just alluded to. And it's compared to commercial aviation, of which we also do a lot. Business aviation is fairly unique in the sense that the person borrowing the money is not the person that's being asked to do the maintenance and the insurance, etc., etc. So, commercial aircraft, fairly straightforward, lend money to an airline in the round. That airline does the maintenance, does the insurance, etc., etc., and basically pays. One of the big differences in business jet financing is, lend the money to the owner to buy the aircraft, but the person doing the maintenance, the insurance, etc., etc., who's got to repossess the aircraft for you as well if it goes wrong, is not that person, it's a third party. And there can be a bit of tension there. What we'll discuss today, loans and leases, finance leases primarily. There are some providers who provide op-lease products in the business jets market, but it's certainly not as big or strong as it is in commercial aviation, where it's like 55% of the market. I think Eddie probably does more leases than loans. I do more loans than leases.
I used to.
My clients only really do leases if there's a particular reason for it, like you can't register a mortgage in that particular jurisdiction, like in Austria, for example, or there's a tax reason for it. But Eddie jumped in. Oh, sorry. Sorry. But in terms of the documentation, which we'll look at, loan documents, personal and corporate guarantees, aircraft mortgages and security assignments, again, one of the big differences between business jets and commercial aviation is because of certainly what I do on the private wealth side, there's often a personal guarantee from the high net worth individual behind the scenes, which, dare one say is sometimes more of a moral commitment to the deal than anything else, than anything that we really seriously think we're ever going to be able to claim on. But it's nevertheless quite an important document. And again, it's a distinguishing factor from commercial aviation, where you'll never see any private individual stepping up and guaranteeing the debt.
So we're going to talk about, again, loans and leases. Leases are, it's a term that can mean one thing or another. We'll talk about that too. Next slide. Actually, buddy, this is you. You're the secured loan guy. Right? That would be an M for Mark.
Oh, okay, so that's an M for Mark.
We practiced ahead of time. You can tell, right?
We haven't done this. We used to do this. Yeah, we used to do this a lot, but we haven't done it since 2019 for obvious reasons. So loans and leases, as I say. So a lease is, I'm sure everybody knows.
You're doing secured loans.
See? Secured loans.
Right.
Do leasing first and then come back. It's less Oasis against Blur than Keystone Corps, isn't it? As I'm sure everybody knows, a lease is a document where I own something, I own an aircraft, and I give possession of that asset, that aircraft, to Eddie, who then goes off and does whatever he wants with the aircraft, subject to what I tell him he can and can't do in the documentation. So a lease is obviously basically where a lessor parts possession with property to the lessee. And there's so many different types of leases which can be extremely confusing. A finance lease is basically similar to a loan but structured as a lease, where somebody is basically paying off at the end of the lease the full economic benefit of the aircraft. So if the aircraft's $50 million and you get 100% financing, at the end of the day, the lessee will have paid to the lessor $50 million plus interest. Compare that to an operating lease, which I say is not common in business jets. Global Jet Capital do it, for example. So, okay, it's relatively common. But it's more common in the airline industry, where the lessor owns the aircraft, leases it short term, 2 years, 3 years, longer, takes it back, leases it to somebody else, takes it back, and they're in the business of sending it out and getting it back and sending it out to another airline. In the business jets world, on the finance lease, that's not going to happen. The idea is execute a finance lease and the aircraft will never come back. It's never expected that it will come back, and normally there's a purchase option where the lessee will buy the aircraft at the end of the period. As I say, the private wealth banks that I act for do that, do finance leases, but primarily where, as I say, you can't register a mortgage, so you can't really do a loan, for example, Austria, or there's a withholding tax under loan payments, but not under lease rentals, and therefore you do a lease structure like a lease rather than a loan. Loan mortgages, obviously everybody in the world does loan mortgages in various jurisdictions, very straightforward, loan agreement, lend the money, get repaid with interest over time. The bank will always invariably take a mortgage over the aircraft, and this is very English law-centric kind of a talk. In various jurisdictions, they can be called other things, so Canadian hypothèque, French hypothèque, etc. But certainly in English law, yes, well, we just call them mortgages.
The theory is, right, we'll give you money, and you better pay us back, right? And you better pay us back according to what the payment terms are. And, if it's a loan or some other kind of secured financing, like as Mark referred to it, a finance lease, you're getting principal and interest back. If it's a lease, it's different. There's a different investment. There's a different way that lessors look at those deals. But, if you don't pay me back, whether it's a loan or a lease, we're taking our thing back that we financed, right? And so that's the role of a mortgage. And then when I talk about American documents, that's the role of a security agreement. A lease will have those same kinds of provisions. We have some slides that follow regarding leases, but you're getting a flavor of both.
Yeah. There's further terminology in the lease world which always causes confusion as well. So dry lease, wet lease, etc. A dry lease is essentially a product where I give the aircraft to Eddie, and he's got full control over that aircraft, subject to what I say in my documentation. He has to go and insure it, maintain it, provide the passengers, etc. in the commercial aircraft world. A wet lease is where I would operate that aircraft on behalf of Eddie. But again, in business jets, so if anybody ever talks dry lease, wet lease, and business jets, wet lease is basically a charter. Dry lease is basically the finance lease. A finance lease is a dry lease.
Dry lease, I'm giving you the thing. The wet lease, I'm making it available to you, right, by operating it.
Yeah. But I think the terminology in the leasing world can cause more confusion than clarification.
There you go. You're still talking about secured loans, right?
Yeah. Okay. Sure. So, everyone will know the basic principles of a loan mortgage situation. It's the same as aircraft, the same as ships, the same as buying a house. Bank lends you the money, you provide a mortgage to the lender over the aircraft. That's a very simple thing to say, but in practice, there are multiple complications in relation to taking mortgage over aircraft, which we'll come on to. But the bottom line clearly is the borrower is expected to repay the loan, repay principal and interest. Interest in the documents that I do apologise, in the documents in the pack. I only noticed at the last minute that they're somewhat on the old side, and they refer, for example, to LIBOR, which now no longer exists, the London Interbank Offered Rate, which has been replaced by SOFR. So if you look in the pack, it talks about LIBOR. That's now SOFR. But other than that, unless you're doing a deal in the Middle East and you have to use Islamic financing, the principles are pretty much the same. Bar has the benefits and burdens of ownership. So as we're saying, it's the borrower, obviously, that's then expected under the terms of the loan documentation to insure the aircraft, maintain the aircraft, etc., etc. It's the borrower who will enter into the management agreement to look after the aircraft. And we'll come on to the sort of obligations that the lender at that point would then expect the manager to pick up.
So we started talking about leases when Mark was doing the introduction. And the term lease, right, it can mean all sorts of different things, to whoever you're saying it to. And it also has, there are characterization issues, which I'll talk about too, but with all of them, let's say it's often 100% financing or refinancing, right? So that's a reason that a customer would want this kind of financing structure. And just like with a loan, right, the lessee has to pay money, right? And the money's intended, instead of just allowing the lessor to recover its principal investment, but also, in other words, they buy it so they pay the cost. They're getting more than just interest because, ultimately the entirety of the economics, because they're paying rent, and then at the end of the term, if they want to buy it, they have an option to buy it. Ultimately, if they do that, then the lessor will recover all of its investment, include not only just the principal and interest, right, component, but also the residual value, because that's the value at the end of the lease term. But it's priced in a way so that the economics that the customer enjoys, and this is another reason they might like this structure, is they're paying a monthly amount that reflects the fact that the lessor ultimately will end up with the value of the aircraft at the end of the lease, right? So they're paying less money. Good thing, right? And plus they're paying less money if, like for example, if it's a U.S. deal and a U.S. taxpayer, right, federal income taxpayer, they get a tax benefit, depreciation. So they'll pass that down to the customer, right? So they'll have the benefit of that in the economics. So that's among the reasons they might choose what we refer to as a true lease, and I'll talk about what I mean by that. The other thing is we refer to them as triple net leases. Even though the lessor owns the aircraft, it's clear that the lessee has to pay all the costs associated with operating. So maintenance, insurance, taxes, et cetera. Even taxes that the lessor might be responsible for. Slide. So, the primary difference between leases and loans, at the end of the loan financing, customer still owns the aircraft. But at the end of a lease financing, if the lessee doesn't renew the lease or exercise a purchase option if they have one, it comes back to the lessor, right? So the lessor is taking that investment risk. And there are two types. So I'm a U.S. lawyer, right? And so U.S. law, the U.S. characterization of things. Our commercial law is state law, right? So if you do a deal that's based on U.S. law, it usually says New York law, right? Because the parties have a choice of law, right, that's going to apply, and so more of them, or most of them, are either English law or U.S. law, and U.S. law really means, U.S. state law, except that there's a federal law that overrides it. So under U.S. commercial law, that's the Uniform Commercial Code, that New York has adopted, that all of the 50 states in the U.S. have adopted, there are two types of leases. There's a true lease, and some people refer to it as operating lease, but that's an accounting term. It's not a commercial law term, right? So bankruptcy court doesn't care that you're saying it's an operating lease. They care whether, and I'll talk about what it means to be a true lease, but if it's a true lease, meaning the economic terms support that, then a bankruptcy court or any other court, when they're deciding who has rights in that aircraft, they will treat the lessor as the owner, right? And so that's different than English law, and Mark can talk about that. But non-true lease is where, for example, if the end of term option is the lessee can buy the aircraft for $1, that's not really a lease, right? The lessor doesn't really own the thing. And that's very clear under U.S. law, like New York commercial law. The lessor is really selling the aircraft to the lessee the moment it enters into the lease. And all the lessor retains is like a mortgage interest, a security interest. Slide. Characterization, just like I said, it becomes confusing. And there's also, there's accounting implications, like what's on the balance sheet. And that has often driven, how some big corporations decide either to lease, right, or to borrow. They don't want it on their balance sheet, or they want it to reflect on the balance sheet as something that they don't own, right? Whatever the reasons are at the time. You mentioned the Green Army, right? So that's one characterization. Also tax, right? If the lessor for U.S. federal income tax, right, owns the aircraft, they get a depreciation benefit, which is a good thing. Like I said, they usually pass that down to the customer. If it's not a true lease for those purposes, right, then the accounting treatment's different and the tax treatment's different. The tests, so a big difference between U.S. law and the laws of many other countries, including English law, is that we're a substance over form jurisdiction, meaning you can put in your contract all sorts of things about, it's a lease and the lessor owns it, et cetera, et cetera. But if the economics are such that under U.S. law, the economics make it more like the lessee is the owner, right? In other words, if the lessee can buy it at the end or has to buy it at the end, or it would be nonsensical for them not to buy it at the end, then it's what we refer to as a non-true lease and the lessee is the owner. But that's, and a similar test for accounting and tax, but not exactly the same. Next. Slide, next slide, thank you. So, most significant implications when comparing the two, the credit considerations, right? I think some of those were already discussed, but priority over other parties. So if a lease, right, it's better to own things under U.S. commercial law than to hold a security interest or mortgage, right? A lessor has better enforcement rights, and it has better rights in bankruptcy. If it's a true lease, so that's a good thing, right? For a lessor. Investment flexibility considerations, like I said, the lessors take a value risk during the term, right? Because it's collateral during the term. And then upon expiration, and that's what's different between a loan and a lease, right? So the lessor has that value risk. So, yes, the lessee has to maintain the aircraft and, be sure that it complies with all the legal requirements and certain contractual requirements. But when they return it, so long as it's in conforming fashion, the lessor is taking a market value risk, right? And that's the big difference there. That's the risk that a lessor will take. And then the lessees have meaningful choices, right? They can decide, well, I like that aircraft for those 4 years, but nah, you take it back. I'm going to go get something else, right? So that's another one of the flexibility points lessees like. Slide. Economic terms. If you're a lessor, you're less burdened by some of the regulatory requirements like usury, et cetera. There's less transparency in the pricing, though, if it's a lease. The other issues, if you're an owner, just put it this way, you're subject to more risk if you own something than if you're just holding a security interest or mortgage. Slide. You go. Okay, go.
Yeah, just one of the great things about being an English lawyer in the aviation business is that you get to do this stuff despite the fact that commonly there's no connection with England or the UK whatsoever. I've spent swathes of my career working for a Swiss bank financing SPCs, special purpose companies in BVI or Cayman, owned by Russians. Can't do that anymore, obviously. But one of the ironies is these documents are governed by English law, and many people would say, well, why is that? Because there's no connection with England whatsoever. And the self-serving reason is that, we poor English lawyers need something to do in our lives, and we've chosen this, and therefore that's, we need to keep that going despite Brexit and despite Cape Town and everything else. But the real reason is, we have good courts in England, good judges that understand this sort of stuff, have been doing similar things in shipping for hundreds of years. So it's a very well considered area of law with lots of precedent, and probably more to the point, one of the good things about English law, and I think New York law is very the same, is that the documents very much say what they say on the tin. So if you have a 150-page, and these are long documents, loan or lease, English law won't. I'm generalising, but English law won't come along much and say, right, you the parties might have agreed that, but actually we're going to imply masses of sways of some civil code you've never heard of to say something somewhat different. If the parties have agreed it and written it, an English court will tend to uphold it without sort of implying too much from outside, which helps when you interpret the documentation. But that's a sort of long rambling introduction to saying that basically the governing law for these documents is basically English or New York. You will get specific documents that require to be under another law, like a French law hypothèque, for example, if you're taking security of an aircraft in France. But generally, it's English or New York. And by English, I mean English and not UK, even though we've put UK law on the slides. But for this purpose, and apologies to all Scotland, etc., UK means English. It also means Wales, but it doesn't mean Scottish, and it doesn't mean Northern Irish. US?
Sure. So how is it that you can have, these financing documents, they're just contracts, right? They're just a form of contract. They have a particular purpose. So how is it that parties to this contract can say, well, geez, neither of us are in New York, for example. How is it that we can say that New York law would apply, and why would some court uphold it? Well, there are regulations, like civil regulations in the state of New York that support that. So if the transaction's above a certain size, and there are some other considerations, then parties to that contract, even though they're not in New York and the plane's not in New York, whatever, they can agree to have New York law apply. And to have, further to that, New York courts be the jurisdiction for the parties to enforce their rights or defend their rights. And so, again, the benefit of that is, although all of the states in the U.S. have adopted the same commercial law, the courts in New York, right, over the course of time, because it's such a popular choice of law, have heard so many commercial cases that the law is fairly predictable, right? Instead of having seven cases heard in a particular state, there are thousands. So especially as a financing party, right? If you're a lender or lessor, you feel confident that if a court in New York litigates, and it's going to be a federal court, if there's litigation at that court, they'll come out with the right decision, or a decision that's predictable. And if you're a financing provider, you want predictability. So that's
yeah, and I think it's also worth saying in that context that banks certainly like the English courts because they're known to be bank friendly. Probably the US courts. Depends which court you're in, which state you're in, I guess. But lenders tend to like English courts because they tend to be lender friendly and come up with judgments which are lender friendly. And obviously that doesn't help the borrower, but the borrower's not really in a position to argue on that sort of a point.
Yeah, California courts aren't, big surprise, right? They're customer friendly. And Texas courts are crazy, and there's some other courts that are just crazy. Conflicts of laws, the way I explain that is rock, paper, scissors. You all know the game rock, paper, scissors? Right, so the rock is, at least for New York, right? It's that state law. Then paper is the federal aviation regulations, like where to file, what to file, to register the aircraft and support your ownership. And then the scissors is Cape Town, like this international treaty that various nations are a party to. So one overrides, right? So rock you start with, that's the state stuff. Federal overrides it mostly. Regarding many of the important issues, and then the international law that overrides, the federal and the state to the extent there's an overlap.
Yeah, it's a very important point that even if the documents are governed by English law, then obviously by doing an aircraft deal, the lender exposes itself to multiple jurisdictions where it needs to consider other laws as well. So it needs to consider the state of registry, which we would call the lex registri because we love that sort of stuff. It needs to.
Is that French? Never mind.
I had a colleague who. Anyway, it needs to consider where the aircraft's physically located at the time that you take security over that aircraft, which is called the lex situs. And I worked on a quite famous case called the Blue Sky case, the Bali case, involving some 747s, which went missing in Iran. And the entire case revolved around how you validly take an English law mortgage over an aircraft, which in that case was physically located in the Netherlands. And that's called lex situs. So again, it's another very difficult aspect of the whole thing. And when you're doing a closing and the bank says, I want the aircraft to, I did one this week, I want the aircraft to fly out of Montreal in this case, and on its first flight to go to England so that we can perfect the mortgage. We never used to have to do that until the Blue Sky case. That wasn't a thing. So now people will always talk about, the lenders will always say, I want the aircraft in England or English airspace. When I take a mortgage over that aircraft, so that I can perfect the mortgage, and that follows the Blue Sky case, and that's the lex situs rule. And I could drone on for hours about it. We actually knew where the 747s were. They were in Iran, but we couldn't get them. That's the problem in the case. But you'll come up with that all the time. Banks lawyers will say, I want the aircraft in England. I want for lex situs because of Blue Sky, and people will say, what are you talking about? But that's the basic rule. What else we got? State of registry? Sorry.
Yeah, no, so one other point there, right, is, like I said, it's a contract between two parties, right, a lease or a loan, and the various loan documents or lease documents. So they can choose the law contractually, but it doesn't mean third parties are bound by it. Right, the governments in which these aircraft might be situated or registered, right? So if it's situated in a way so that some some other state actually, or some other jurisdiction, some other national jurisdiction could apply a tax, they can. They're not bound by what the papers say, right? Same thing if there's a competing lien holder, right? Whether it's whether it's a maintenance-related lien or a landing strip lien or whatever it might be, or a tax lien. Whoever it is who has the rights under that lien, they're not subject to the choice between these two parties. And then especially if there's some enforcement action in the aircraft somewhere else, right? So you would hope that that particular jurisdiction was a signatory to that Cape Town Convention, because the Cape Town Convention essentially has Uniform Commercial Code provisions, right? It has the protections available to lessors and to secured parties that's now become pretty much international law if that jurisdiction's adopted that treaty.
Yeah. Enforcement's the interesting one because, so if we're setting up a deal, we can cope with, there are certain parameters that we know what we're dealing with, and we can then take legal advice. So as I say, we know which state of registry the aircraft's going to be located in. That will have implications. We know where the aircraft's going to be when the deal is closed, and that has implications, or at the very least we can insist that the aircraft be in a certain place. But we don't know where the aircraft's going to be on enforcement, repossession. That's the kind of the unknown factor. So the bank will analyse the whole situation. It can get comfortable with the state of registry. It can get comfortable with where the aircraft is from a tax perspective and from a security perspective, etc. But enforcement/repossession is kind of the unknown, and but that's why the loan documentation will often say, we want the aircraft to be habitually based in Switzerland, for example, because we know that Switzerland's a fairly helpful jurisdiction from an enforcement perspective. And that's why we don't want the aircraft located in, I always pick on countries at this point and get into trouble, but we don't want the aircraft based in Serbia because Serbia's not a member of the EU, probably not a Cape Town Convention state, and is known to be a bit difficult because of other experience that the bank may have. That is the sort of analysis that the bank will go through.
You want to do the next one?
So I was just going to mention on Cape Town. So Cape Town, so Cape Town is an international treaty, applies by virtue of being ratified by individual states, and has been ratified by about 140 states, I guess, can't remember the exact number, but it's with some noticeable absences like France, Germany, etc. Quite a few EU states. It's a very well ratified, very well known convention, and we can have another discussion completely on Cape Town, and people will say, oh, but it's never, when have you ever used Cape Town to enforce? And to be honest, I never have, but I've certainly used it as a stick to threaten to enforce, and it has benefits from that perspective. So just a basic structure from an English law perspective, which I'm sure everybody's very familiar with. So if a loan is taking finance from a bank under English law, loan agreement, very nice, hefty, long document, 150 odd pages. I think I'm probably.
It's probably 100 pages more than you need, but
no, because I think English law. No, we get criticised for this, but I think English, as I say, one of the benefits of English law is everything's in there. So if we have to write pages of stuff, New York's the same. If we have to write pages of stuff to make sure everything's in there, then I think that's good because the parties at least understand, if they read it, where they're coming from, what's going to happen and where they're coming from. You will have banks. I mean, we were talking about this earlier. You will have banks that just say, right, here's our standard T's and C's, terms and conditions. Sometimes they're on our website. They're in really small print, so you're not going to mark it up because you can't even read it in the first place. And for certain sort of smaller aircraft, that might be fine. I do know lenders in the market that will just literally say, here's our $4 million financing. Here's our T's and C's. Take it or leave it. And that's fair enough for that sort of a market. But I think if you're talking sort of ACJ, BBJ, that you're not really going to be doing these sorts of documents under standard T's and C's.
For U.S. documents, you'll see the big difference between. Oh, sorry, go. Because we have longer slides that go through each of the documents.
Yeah, sorry. So actually, we will go into the security in more detail, but I think just to flag, as I mentioned previously, in the business jets world, you're likely to have a personal guarantee, so the lender will say, the lender will always invariably lend to the special purpose company which will own the aircraft, whether that company's in Isle of Man or BVI or Cayman or wherever. But that company doesn't do anything other than own the aircraft. So from a credit perspective, that particular company itself is useless. It's not doing anything. It's just going to own the aircraft. And the lender likes that because it doesn't like borrowing vehicles to do other things, to own other assets, to have other creditors, et cetera, It likes them to be what's called creditor remote or insolvency remote. But certainly the private wealth banks that I act for then will say, well, actually, to have some proper credit on the line, I'd like a corporate guarantee from a corporate that owns this aircraft behind the scenes, or I'd like a personal guarantee from the high net worth individual themselves. And in my experience, high net worth individuals are usually fine to give that. Sometimes they try and have limits on the liability under the guarantee, et cetera. But in general, as a general proposition, they don't tend to push back on the proposition of giving a personal guarantee. But again, different jurisdictions have different rules. So you find that if you get a personal guarantee from somebody in Belgium, for example, you have to have what's called spousal consent. So if the high net worth individual male has to have his wife sign to say that she agrees that he's giving a personal guarantee. So again, the bank has to analyse different rules in different countries dependent upon where the personal guarantor is coming from. And then, dare one say, the bank certainly when we used to do a lot of Russians and a lot of Russian personal guarantees, you think long and hard, thinking, well, are we ever seriously going to try and enforce this in Russia? Where does the person have assets? Do they even have assets? Well, your average Russian used to have assets in the West anyway, so that wasn't so much of an issue because you think if we have to enforce this personal guarantee, he's got a property in London, he's got whatever. But then the issue is that a lot of this property is not held in the individual's name. So you get a personal guarantee from, okay, bad example, Boris Rottenberg, and suddenly you find that, okay, Boris Rottenberg doesn't have anything in the West in the name of Boris Rottenberg. It's all in SPC 1, 2, and 3, etc. And then you have the issue in certain jurisdictions of trying to prove that actually that's his, and you can what's called pierce the corporate veil to get through to the individual. But English courts don't tend to like that. Aircraft mortgages, I've said, security of the aircraft itself. Lenders won't tend to like anybody else having a mortgage, as I think Brendan mentioned on a previous talk. So it always tends to be first-ranking mortgage, but the only mortgage anyway. As I said, there's so many issues around taking mortgages for the lawyers to have to deal with, which I won't bore you with. But I think the most important one from a practical perspective that you will come up on deals, as I've said, is under English law, the lawyers will say, well, we want our aircraft in England or in English airspace in order to take this mortgage, and that follows the Blue Sky case. But I think that's quite an important point because it's a bit strange and it's a bit counterintuitive. So I just did a deal, as I said a second ago, where we took an aircraft from Montreal and it was going to Africa, and we wanted it routed on its first flight via England. And obviously people query why that has to be the case, but it has to be the case. Next.
Oh, it's my turn. Well, a lot of what Mark said is similar as you get to U.S. law, U.S. Characterized transaction documents, right? So in other words, if it's New York law or if it's some lender in the States, generally this is their financing package. And the loan agreement is different because it usually doesn't have the payment terms, but it might, right? So alternatively, you could put the payment terms in what we refer to as a promissory note. And there are reasons to do it, but there's not enough reasons to have that traditional approach stay the same. So you might now see the modern trend being that the loan agreements have all the payment terms as well. Guarantee, right? We have more detailed slides later that will cover a lot of this, but the same idea, right? Guarantee means you're going to give me the money if the customer doesn't pay, right? Whoever it is who signs that guarantee, whether it's a corporate or an individual, whatever, and it's got to be the case that it's absolute, right? Guarantor has to pay. It can't be a defense, and there's quite a bit of content in a guarantee that covers that, right? That the guarantor will make it clear they have no defenses. Aircraft security agreement, it's our U.S. New York law term for a mortgage. Same thing. That's how we get our aircraft back, right? Not our collection remedies, but our repossession and enforcement remedies would be covered in the aircraft security agreement. And then security assignment of purchase agreement warranties, right? We want to have the whole package of rights that the customer has that go to the value of the aircraft, right? So if there are warranties associated with the aircraft and the lender has to repossess, right, they want to have the benefit of those warranties. And if this was a progress payment financing, and those are fairly common, that's really the collateral. The collateral is going to be the purchase agreement itself. And it's the manufacturer's promise to return the progress payments that were made, the deposit, to the lender in the event that the customer doesn't ultimately buy the aircraft and the deal close. Next.
Yeah, just looking at one thought I had whilst we were speaking is English law and New York law. Of course, it also applies to sale agreements. Everyone will come across that ordinarily. That sale agreements typically governed by English law and New York law. And again, you might say, well, why? Because seller's not UK or US, buyer's not US or UK or US. But I think from our perspective, it's the same sort of thing. The sale agreement will set out in detail exactly what's going to be happening, and no one's, if you had, with all respect to German law, if you had it under German law, a German lawyer would come up and say, in enforcement, and say, oh, but you missed 20 sections of the German civil code that you didn't know anything about that says your deposit's not coming back after all, or whatever. English, as I say, English law, it does what it says on the tin quite nicely. And I think it's probably even more important in the sale agreement context, because swathes of what are in a loan agreement is fairly standard. And I've never litigated against any of it or had a dispute in relation to any of it. But boy, have I had disputes in relation to sale agreements and the interpretation of particular provisions in sale agreements, and I've litigated them as well. And that is where the clarity of the language is of critical importance. Then ironically, a sale agreement, of course, is a far shorter document than a loan agreement, and yet it should be going. Typically, they're quite short compared to commercial litigation. They should be going stuff in a lot more detail. So basic loan structure, we've kind of gone over. I guess the points to mention really, I've touched on them before. The borrower, as I say, will not be. So if you're lending to Mr. X worth $25 billion, the borrower is clearly not Mr. X worth $25 billion. The borrower is special purpose company in the BVI, owned by another trust, which ultimately might be owned by Mr. X, but who knows, because the chain of ownership documentation is so structured and confusing that it gets quite hard to actually work it out, and you just take it on trust that, hey, if he's the one flying around in the aircraft, then he probably owns it. But the key point really is aircraft are owned by special purpose companies, one aircraft, one company, and these are typically offshore for the tax and etc. reasons that everyone's familiar with, and they're not owned. They are not, in my experience, ever owned personally by personal individual. And one of the main reasons for that, from a personal individual perspective, is ownership of aircraft sometimes brings strict liability for certain things. So, for example, ground damage in the UK, if an aircraft causes ground damage, the aircraft owner is personally liable for that under strict liability, i.e. they can't say, oh, that wasn't my fault. If a piece of equipment falls out of the aircraft and damages somebody on the ground, the owner of that aircraft is just liable with no defence. So no private individual wants that kind of liability. So aircraft are always parked.
So how do you handle KYC?
We have a really good team at Clyde & Co that does the KYC for me. But I mean, it is an issue. Blind trusts. You can have shares in blind trusts. You can have discretionary trusts, charitable trusts. So you can have shares in these SPCs, where it's not necessarily owned directly by the individual, but held on, e.g., discretionary trust by the shareholders. Yeah, for sure. You have to go. I mean, I've seen layers. I'm sure everybody's seen layers of structure that are 5, 6 companies high, and you have to. So certainly from our KYC perspective, and KYC's. It sounds a silly thing to say, but it's far more important now than it was. I mean, that's a crass and silly thing to say, but you know what I mean. You have to go all the way up the chain to the individual at the top.
Well, I was just going to add that I hope it's a trend, but the more companies we are putting together for clients, actually it's becoming far shorter because the cost to the client of all the people having to do the KYC at all of those chains is just becoming stupid. So actually a shorter one, because what is it confidential if you're going to wear a paper bag on the aeroplane getting on and off?
Well, I mean, the thing. There is. I think there is also certainly a trend for it to be simplified because owners know that KYC is such an issue for banks and law firms, etc., accountancy firms, etc., that they'll now have a pack readily available. So very switched on owners, and anybody who's advising owners, I certainly recommend this. Very switched on owners have a KYC pack ready and available for anybody that you're dealing with, accountants, firm, whatever, tax advisors, so that when they say, can we see evidence of the ownership of the high net worth individual behind the scenes, it's there, ready, and it's immediately available. And as I say, some owners, and source of wealth, source of funds as well. I've had owners who will provide a source of wealth statement saying, I founded X business and then I sold it and I made $250 million when I sold it. And boy, it's beautiful. You just think, wow, this saves so much hassle and so much pain. So I think very switched on high net worth advisors will have those sorts of packs available. But I agree there is a tendency to make it more straightforward, and I think partly to get over the KYC hurdle, which is becoming quite a big hurdle. But then the irony is, of course, that you're right. The owners will then, I've got owners who hide. Sorry, that's a bad word, but let's use it. Their ownership in offshore jurisdictions, especially these days when the green lobby is out in force, and then they'll go and slap their name on the back of the aircraft in a way that's really quite obvious. So I always quote. It's Burkhan. There's an aircraft called Burkhan, which used to be owned, which is now sanctioned by Alisher Usmanov. Well, his father was Burkhan, so his middle name is Burkhan, being Russian. So it's obvious. It doesn't take a lot of digging to work out who these aircraft are actually owned by. But and then of course you can see them on Flight Tracker anyway, etc. But sorry. So that was a bit of a digression on the borrower. But so as I said before, from a lending perspective, that's useless because you're lending an SPC to buy an aircraft, which you're taking a mortgage over with your money. So you need somebody else to step up from a credit perspective, and the somebody else has to really be then either a corporate, if this is a kind of more of a corporate financing for a corporate which is using the aircraft, or certainly more the case in what I do for the private wealth banks, so as a personal guarantee from the high net worth individual themselves. Then borrower gives them, you can't see it very clearly in the black and white, but borrower gives a mortgage over the aircraft, a security assignment of various things like insurances, powered by the hour agreements. We like to get hold of basically anything connected with the aircraft that if we think we need to repossess that aircraft that we might need. So Rolls-Royce corporate care, for example, there's documentation in place where the lenders will have rights in relation to the corporate care agreement. So if the lender take the aircraft, we've got rights in that agreement, and that's very valuable because those sorts of PBH packages provide a lot of value to the aircraft itself, and we need them.
Slide. So same stuff, right? Not a whole lot different. I will say regarding KYC, in the U.S., we have the Corporate Transparency Act as well. And so there's now, it's now a federal law, right, where the reporting has to be very precise, and it goes all the way up the chain. Plus, when the FAA came up with the Reauthorization Act a couple of years ago, they also changed the requirements regarding registering an aircraft. And so there has to be much better and fuller disclosure regarding who the owners are. And so for many years, there have been some efforts to obfuscate who the owner is by having double trust and the like. The government really doesn't like that in the States, right? And as a matter of fact, they've now made all of the FAA registration records, including all of the clarity regarding who really owns the asset, available to all the various agencies, the TSA, the CIA, et cetera, because it's become a big concern in the States. Next slide. We have 15 minutes left, pal.
Yeah, no, that's fine. So the first stage in a financing, as I'm sure all of you have seen, is a term sheet. There's an example of a term sheet in the pack. jumping to the bullet point, and I'll come back, is sort of sales v legal. One of the things about a term sheet is how much information. I think the bottom line with the term sheet is similar to an LOI on a sale agreement. Is how much information, how much detail do you want in it? How much upfront do you want to go into? I mean, obviously, it's got to have the key points like what the margin's going to be, what the, whether it's term software or cumulative compounding software and all that sort of stuff. So, there's some basics. But I think certainly if I'm acting for an owner, looking at a term sheet and it's like 15 pages, you do kind of think, well, this is maybe going a bit, far at this stage. And one of the other points there being, you're kind of locked in. So it's very difficult if you're negotiating on behalf of an owner with a bank and they've signed a term sheet to then veer away from that term sheet when you do the documentation, because the bank's lawyers will always say, oh, but it's in the term sheet, and therefore, close book, that's end of story. That's quite a hard thing to argue against. It's similar to arguing, when you're negotiating a sale agreement and you're trying to go against something that was in the LOI, even if it's manifestly wrong or unreasonable, it's a very difficult thing to say that, you should go against it because the parties have already agreed it. So let's say key commercial points, obviously the loan amount, the term, the interest rate. We haven't touched on LTV, which stands for loan to value. So obviously a bank, not obviously, but most banks will not give you. So if you go to a bank and say, hey, I want to buy a BBJ for $100 million, can I have $100 million, please? Of course, most banks will say, sorry, we can't really do that, but we'll give you 75 million, which means your LTV is 75%. Banks won't tend to. I mean, in my experience, a typical LTV these days, banks in the West Europe market, I don't know about the States, won't tend to go up more above 80%. So 75% is probably the average. And there's a danger for, just touching on LTVs, there's a danger for the borrower getting too excited by a high LTV because banks are very keen on banks are very keen on margin calls, which means that if you've done the deal and the LTV then slips so that the LTV is going, say, up to 85%, then the bank will insist on a prepayment or extra security to bring the LTV down to what it should be, 80% or 75% or whatever it should be. Obviously, with the benefit of the amortization profile, the LTV should go down over time, so because clearly you're repaying the loan over time, and therefore, halfway through the deal, you should have repaid half the deal, and the LTV should be down to about 50%. But certainly during the financial crisis, 2008, a lot of banks were making margin calls against business jets owners, and it caused it was one of the most painful things in the market I've gone through. It was quite extreme because owners in that situation are quite cash constrained generally, and they don't want to have to sell shares to repay a margin call for the bank.
When Mark refers to margin call, he's saying literally the bank will accelerate the loan and say, okay, you reached this particular promise that the value of the aircraft would always be at least this relative to how much money you owe. And the banks care about that because if they don't get paid, right, they need to be able to exercise their right to repossess and sell the aircraft. Well, if the aircraft, therefore, has to be worth at least as much as what the loan obligation is so they can get repaid. That's why they care about that.
Yeah, and there's logic to that, obviously, because if they enforce, they've got legal costs, they've got to pay the manager. The manager will say, oh, I'm owed $1 million, so they have to pay off the manager. There's always costs which add up, so they need a bit of leeway between the value of the aircraft and what they're owed, so that when they do sell, there's a little bit of wiggle room.
Banks don't want to enforce, right? They just don't. They want to get paid. And so that's why you see them be a little bit more relaxed on certain breaches. But, at some point, if they have to, the time and money, right? Because it's also time value of money, because it takes a while.
Enforcement is a painful process. I mean, we could do another session on enforcement. But invariably, when you enforce, the aircraft's not in condition, the manager rocks up and says they're owed $2 million and who's going to pay them? And if they don't get paid, they're going to exercise a lien over the aircraft. The aircraft's in a shop and the shop says they're owed $1 million and they're going to exercise a lien over the aircraft. Some government authority rocks up and says, hey, you owe us your control charges or airport charges. There are a lot of costs on enforcement. I don't think I've ever done an enforcement. I've done loads, but I don't think I've ever done one where the bank sort of suddenly walks away with 100%. repayment, you almost invariably expect a hit. But sorry, back to that's a bit of a digression, but back to the term sheet. Binding or non-binding, it's only a term sheet, so it should really be non-binding. But as I say, it's binding in the sense that once you get to the documentation, you're not really going to be able to get away from what this says. But it's non-binding in the sense that if you don't do the deal, no one's really going to sue on the back of this. It's non-binding in that sense. In the same way that an LOI in relation to a sale agreement should be non-binding in the sense that if it all falls apart, no one's going to sue on the back of an LOI. Though I've seen plenty try. But that's really not the idea. It's non-binding until you enter into the full pack of loan agreement documentation. Subject to credit approval. This is inevitable really from a borrowing perspective. The bank will say the whole deal is subject to credit approval. And if I act for owners, it's like, well, why? Because we've gone this far. So surely you can give some sort of commitment that your credit risk people are going to approve this deal. But it's fairly normal that the lender will say this has to be subject to credit approval. And then it identifies borrower, lessee, guarantor, etc. All the basics to the extent you can. State of registration. We do a fair amount of PDP, pre-delivery payment financing, where you're paying the manufacturer, and at that point you might not know what the state of registration is going to be. The owner might not have decided. I'm doing Gulfstream 700s, which we sort of did the documentation for years ago, but because they've been delayed for so long, we're only now closing, and the owners are only now choosing the state of registration. Same with the operator; they're only now choosing the operator. But from a lending perspective, that's fine. The lenders will have their preferred state of registry; they'll have their preferred operators. They won't be so keen if you want to go and register in. I don't say. Everyone knows there's some states of registration where lenders will not be keen to lend. There are some operators which some lenders don't get too excited about. They probably won't say it quite so bluntly, but it's just the way it is. But all this sort of stuff gets identified in the term sheet to the extent possible. I think the sales of illegal point is what we were saying before, isn't it, Eddie? Is this a selling? It's the same similar to an LOI with the sale agreement. Is this a selling tool to get the deal? Or is this actually setting out sort of key legal points? And many banks will probably think, well, actually, it's a selling tool to get the deal.
In the U.S., many of the lenders, especially the banks, right, like PNC, these are relationship transactions. Like they have a relationship with the customer, they desire a relationship with the customer. And so they never expect to get the aircraft back. They never expect to repossess. They decide that they're going to lend money because they expect to get repaid. There's some aberrations that are more collateral specific, and with some of the independent financing providers, like the investor types, right? They're going into a lower sort of tier of the market, and so they do better, right? They get higher yields, but generally, right? It's you want the deal, right? So the term sheet is to get the deal, and then you negotiate the documents. So there's not as much of a legal focus on the terms. I think
it impacts on enforcement as well. So, in the commercial aircraft world, if an airline defaults, generalising, but if an airline defaults, the lessor will say, right, bang, I want my aircraft back now, and I'm enforcing it. That's it. Here are my Cape Town rights. Here's a letter of default. I'm taking it. Obviously it depends what bank you're dealing with, but certainly in the business jets world, where it can be more of a sort of private wealth play. I've certainly done, careful what I suppose, I've certainly done deals where the lenders will say, sorry, private wealth doesn't want to enforce against that person because he's too significant a customer of the bank.
Or she.
Well, that's another topic, it never is. Which is an indictment of the entire industry, but there you go. So other factors will come into play in the business jets world, where, as I say, somebody will say, sorry, there's still a significant customer of the private wealth bank, and the fact that they're not paying out on the aircraft, so what? Because you've got security over it, so you can just wait and join the queue.
Next slide, please.
We've got some slides on sort of what a loan agreement looks like. I think we've only got a few minutes, and it's not really worth going into these in any detail. There's an example in the pack, and if anybody ever has any sort of particular questions on any of these sort of points, then feel free to contact us. In the UK, we've put UK English law here for these slides, but I think it's just New York law is very similar. It's just New York law documents tend to have much longer paragraphs that are incomprehensible and use lots of
Oh, stop.
capitalized words that get too difficult to read.
Ours aren't double-spaced, with all those difficult English words, right, that we don't bother with anymore.
Yeah, but they always use the same word like 10 times. So they'll say, so you don't say, oh, I'm going to sell the aircraft.
No,
Sell, transfer, deliver.
Not my documents, right? But anyway, so in their sample forms as well. The rest of the slides will give you the information you need. If not, you'll just ask us. But are there questions? Because we have 4 minutes left. Any questions? Sick of hearing lawyers talk about any particular issue?
I know it's probably not able to or willing to answer the question, but are you treating certain authorities differently? Isle of Man, San Marino, Aruba, Cayman, Bermuda, right? And of course, are they not following either UK law or New York law? Or is that
Yeah, I guess it's dangerous ground, but certainly from a lending perspective, as a lawyer for banks, there are certainly some states of registry that I get much more excited about if the borrower's chosen them than others, for sure.
Excited in a good way or bad way?
No, in a good way. I mean, well, it depends what it is, obviously. I don't know what to say. There are some registries I don't like, and there are some registries I do. And that's just the way it is. And I think the lenders, and if I feel that, the lenders probably feel that as well. So dare one, okay, let's be controversial. Dare one say, I like the Isle of Man, I like San Marino, I don't like South Africa, I don't like Luxembourg, it's just experience, isn't it? I don't like, and for perfectly legitimate reasons, not just an instinctive thing. So I've just done a deal in South Africa, but I'm not going to get my mortgage registered in South Africa for 3 weeks because that's the way the South African registry works. And from a lending perspective, that makes me uncomfortable. And it's a rational, fair enough reason for picking on, sorry to pick on poor South Africa, but they are slow in registering mortgages. They take 3 weeks. I had to deregister an IDERA from South Africa. It took 2 weeks. I mean, that's ridiculous. I'm sorry. Isle of Man, you can do it in an hour. Dare one say the Isle of Man's probably too easy to do that sort of stuff, but hey, at least it makes life straightforward. South Africa, we were selling an aircraft out of South Africa. It took 2 weeks to deregister the aircraft, and we almost lost the deal because we couldn't deregister the IDERA. So, yeah, Aruba I'm not massively keen on either, sorry. I shouldn't say that.
Yep. Mexico, it takes about a week because they don't do wires. It's all over. I mean, it's not overnight either. It's mail. So it takes about a week.
Yeah.
I mean, the good thing about U.S.-centric transactions, we're not as, let's say, tax-focused as the folks over here. So we don't have, 5 different jurisdictions that have nothing to do with the parties or the aircraft, other than they situate it that way. And so it's not as complicated. And there are many U.S. lenders for a great deal of time who wanted to be sure the aircraft were registered in the U.S. So in other words, they could have parties from elsewhere, but they would use some non-citizenship trust to be sure the aircraft was registered in the U.S. because they knew the rules, they knew the procedures, they knew the timing and investment involved in if they ever had to repossess.
One of the things I like about the FAA is you get a full pack of information. If you deal with a US registered aircraft, you can get a full FAA pack of the history of that aircraft, bills of sale, everything, leases, trusts and leases, owner trustee documentation. It's great. We haven't even touched on it, but from investigating the title to the aircraft historically perspective, which obviously lenders want to know that the person buying the money does own the aircraft or is going to be buying the aircraft. That sort of history of the aircraft is really useful.
You had a question?
Yeah, thank you. Well, Mark, you explained before that the UK courts or London courts have a wide experience with aircraft transactions.
Yeah.
And one of the security means with an aircraft financing are these irrevocable power of attorneys.
Yeah.
Now, is there one single case in which a lender and the borrower found themselves in a dispute, and the lender had to enforce such an irrevocable power of attorney?
It's a good question because I think you've caught me there. I don't know of a case where a lender has had to use an irrevocable power of attorney, to be honest. So this is a deregistration power of attorney which the borrower will give to the lender to say if you have to enforce against this aircraft, use this document to go and deregister the aircraft, present it to the state of registry, and it'll be you'll be able to deregister the aircraft. I'm not aware of a case in England, to be honest. I'm aware, I'm certainly aware of. I've had cases in India. I've had I've had one case in India where we weren't able to deregister the aircraft for 3 years. It was just a world of pain, and sorry to pick on India, but I'm not alone in that. The aviation working group has a lot of material on use of deregistration of powers of attorney. And the idea is in India, but I think the Indian courts have tried to make it a more straightforward process. But there certainly are. Yeah, sorry. So I'm not aware of one in the English court, but there certainly are jurisdictions in the world where deregistering an aircraft has been difficult. And obviously, if you can't, it's a massive thing. Actually, there are two massive things really in terms of enforcement. Sorry, over time, but if you can't deregister an aircraft, you can't sell it, except I guess internally in the States if it's US registered. So fine, but if you repossess an Indian aircraft, you really want it deregistered in India and then sold somewhere else. And the other one is the records. So I'm doing a case at the moment where I've got the aircraft, but the records are locked in a room. I won't say where, but it's not in England. And getting hold of those records is we have to go to court. It costs a lot of money. It's a real pain.
In the U.S., a anomaly among all the other nations of registration is that it's an ownership registration, right? So the owner of the aircraft is the registered owner. In other words, an operator can't register. It's got to be the owner. The implication of that is if your borrower, right, is the owner of the aircraft or one of their special purpose companies, if you don't have the authority of that registered owner, as if you're the lender, right, you want to get this irrevocable power of attorney so you could act on the registered owner's behalf to cause the aircraft to be deregistered, right? Because you have to have it deregistered so you can sell to a new owner who will need to register it, and it can't be registered twice at the registry, right? So that's why that's relevant.
Yeah. So and as you'll know, in the UK we have it's basically an operator's registry. So if you have an aircraft that's operated by, say, Gamma, and then Gamma have the ability to, because they're charterer by demise in the terminology, to register that aircraft at the UKCAA. So if I'm lending to the owner in that circumstance, I want a deregistration power of attorney from Gamma, and I want an idea, and I want a coordination agreement. I want a tripartite with Gamma to do certain things, including deregister the aircraft if I insist on it. And so apologies, we've run out of time. We didn't touch on tripartites, but as I was saying at the beginning, my relationship as the lender with the operator is one of the key things, probably even more key, to be honest, than with the owner. In my experience, when I've deregistered, when I've repossessed, the owners have tended to just disappear, walk away, say, hand the keys back. I can't pay for this aircraft. I've had enough. I'm not using it anymore. Here's the keys. Just go off and do what you will. And the fights that I normally have with the lender are with the operator, not with Gamma. They're one of my clients, so I wouldn't say that. But almost invariably, you rock up to get the aircraft, and the owner and the operator. The owner's disappeared. Sometimes literally, I've done Chinese gentlemen who've literally gone off the face of the earth, and the operator will say, "Hey, but sorry, they owed me $2 million, so pay me and I'll give you the aircraft back. But until you pay me $2 million, you're not getting your aircraft." And then most of the fights are really between the lender and the operator.
It's not quite as intense a focus with most of the U.S. lenders because they tend to be focused on the credit, right? They're lending to people who can pay. They really don't want that aircraft. They don't ever want to enforce. So they have all the enforcement provisions as a JIC just in case, right? And they have to be enforceable and it's important to them, but they're counting on getting paid, right? So that's a difference. There's alternative lenders, right, who focus more on the aircraft, and good for them because they can charge higher interest rates, right? They can
make sure that the management companies are being paid.
Right. So
Yeah.
if you're an
So you
alternative
need
lender like
information
that,
from the management company, and you need these forms, monthly review forms, and you need all that stuff. And if the management company's not being paid, the lender needs to know. But in my experience, if the manager's not being paid, they'll be busy trying to get paid, not necessarily ringing the lender and say, "Hey, we're not being paid," because the lender's not going to be much help. In fact, they're going to be looking after themselves.
So just going back to the Indian government not allowing use of the deregistration of attorneys. Where did that leave them with the international register of Cape Town Treaty?
It left them with a very nasty letter from Jeffrey Wool, I think. That's pretty much what they got. Similar to President Putin when he re-registered 600 aircraft in Russia when they should have been in Bermuda. I think he got a nasty letter from the Aviation Working Group, and that was the end of that. Yeah. No, I mean, I'm being a bit cynical. The lobby groups did raise a fuss about it, and the Indian regulations have been changed to make it more straightforward now. In theory, if you've deregistered an aircraft in India under Cape Town, it should take 5 working days. In my experience, it took 3 years, but that was under the old rules. In fact, it took longer than 3 years. We never did it. It's infinity. We're talking about what? Possibly.
Mark.
Sorry. Yeah.
We good?
Yes. Thank you very much. Thank
If
you.
anyone's got any other questions, there's plenty of time later, but I'm conscious there's an evening of stuff and it's already been quite a long day. So thank you both. Thanks, Eddie. Thanks, Mark.
Pleasure.
Well,